But let's see also what we have on the front page of the Daily Nation, because this is also what is on the fore of the country right now as far as politics is concerned. Raila's plan to unseat Uhuru. NASA lawyers claim President Kenyatta breached constitution by deploying state resources for campaigns, but IEBC stands by its tally, saying the opposition is on a wild goose chase. This one is well fleshed out on page 4 and 9 of the Daily Nation today. And of course, also the arguments are given there in brief on who leads, on the ballots, also on the maths formula. And then we have responses also from Kenyatta and IEBC lawyers on the KIMS systems, on overall petition, and on results forms as well. Okay, looking at that particular development that we had yesterday, and of course they presented their cases and their arguments as well, what really came to the fore as well, and I know that we discussed this on that forum, was the issue of campaigning using state resources. Maybe we can pick up your brains, Miguna Miguna, on this before we go on with the rest of the panel.
Yes, an interesting case going on, and I have a few observations to make.
Yeah, first of all, give us the overall observation. Then before
the overall observation is that in terms of substance and quality of submissions, Paul Mwangi stood way above everybody else. Mm-hmm. Paul Mwangi was just way above everybody else. Not in terms of rhetorics, but in terms of real quality submissions that lawyers would gain from. Mm-hmm. It distinguished very clearly the rule that ought to have applied in the Supreme Court decision of 2013 from what happens in the Commonwealth. The word and or, very significant, mm-hmm, as to whether or not, if violations have occurred in a presidential election and they are significant enough to make the court determine that the elections were not free, fair, and credible, whether or not the court should move to the next question, that these violations, if taken into account, mm-hmm, would result into a change in terms of numbers, in terms of the total tally as to who won the elections, that you don't go to the next step. That was very important. And Paul Mwangi meticulously went case by case from one Commonwealth country to the other. The only thing they failed to do, including Mwangi, when they cited the Canadian cases, they failed to understand that in Canada there are two sets of cases. What we call pre-charter and after-charter, post-charter.
Yes.
The Charter of Rights and Freedoms in Canada was enacted in 1982, just like our Bill of Rights was enacted with the Constitution in 2010. And so the cases pre-charter do not apply anymore in terms of constitutional value to analyzing anything. The cases post-charter are important, and they didn't make that distinction. And I think the court was not conscious of that. So people just threw cases around without distinguishing what are the values. Another thing they did not distinguish, what are the political, constitutional, and legal environments of these countries vis-a-vis Kenya? For example, in Canada, there is no electoral commission. Elections are run by civil servants. Nobody would expect anybody to forge a ballot paper or to change a Form 34A or 34B, 34C. Nobody talks about that. Ballot papers are marked by pencil in Canada, not even by pen, because nobody expects anybody to erase them. The votes are counted by the civil servants, and there are no agents for political parties, and everybody accepts the results. Because of the inbuilt integrity, and the electoral system is completely manual, except the register. The register is electronic. That's the only thing electronic. Everything is manual. Everybody is registered manually, and you don't even have to have your fingerprints. They send you the registration in the mail, you fill it up, you send it back. The register is kept. You go there, they identify you with your driver's license, and you vote. Then you leave. The votes are counted, they are tallied, the results are announced, and the country moves on. We have not reached that threshold. And that is important for the lawyers to have distinguished, because it's not the same environment. Nobody expects this thing to happen. The second thing I needed to say, and let me say it very quickly, is that it was very interesting. Nyamodi is a very good lawyer, but yesterday I was puzzled at his submissions. Because on the one hand, he's saying, he tried to define what a portal is, the public portal. And he said that what was beamed on TV screens was not a portal. But then he said a portal was something else. But this something else was not displaying results. And it was not displaying what the chairman called statistics. He called it data. But he did not say where this data is coming from. But then he distinguished that the results came from 34As. Yet, as of August 11th, when the results were announced, he acknowledged that the National Tallying Center had not received all Form 34As, and in fact, tens of thousands were still outstanding. But then the chairman announced the results using Form 34Bs that could not be generated unless you had Form 34As. Yet, Form 34As had to be remitted to the tallying center simultaneously with Form 34Bs. So you see, there was a conundrum there and a confusion that the court needed to poke and ask searing questions of the submissions and what was being tendered to them, and none was asked. I was puzzled. PLO Lumumba gave a robust articulation in terms of a rebuttal with no legal substance. It was just rhetoric. And I felt that it was very unfair to Raila Odinga's affidavit, because all the affidavits filed in court did not follow the rules. All the affidavits of the first respondent, the second respondent, the third respondent, and of Raila Odinga, argumentative, full of opinion.
Thank you.
Affidavits must only contain facts.
Thank you. Let's hear from Mithika Linturi, your reaction, your general observation as well.
And the power listening to my friend Miguna means completely that Miguna did not do anything else yesterday. He must have been glued on TV. Correct. Watching this case.
Correct.
And I did not have that advantage because I had some other matters in court yesterday. So in a different court. But listening to what he is saying and what I just seen, the clip that you just ran, I am persuaded to adopt one view, that since the matter is before court and the substance of this case and its merit can only be determined by the 7 Supreme Court judges, and because each party in that particular case as an opportunity to put his position clear, then I'd rather leave it to the courts to make a decision and clearly say that we have a difference between, or there's clear difference between NASA and the court team, and because we believe that disputes or the dispute resolution mechanisms that have been put in place, and this is a dispute, and this matter is before the right institution, the right body to sort out this problem, we want better leave it to the courts, and only those that believe in institutions await the decision of that institution and commit ourselves to be bound by the decision of that particular institution. That is what I would want to hear, and this is what we've been trying to challenge. Anybody else out there, whether it's Raila, whether it's Uhuru Kenyatta, and I believe Uhuru has been very clear that even before we went for election, I will be bound by the will of the people. If I lose, I will hand over. So he won. So even in this case, I would personally say that it is quite unfair to test the will of the people in court, because elections are won on the ballot. People decide who the president or the senator will be. And from the outcome of all the results, look at the Senate, how senators were elected, governors were elected, members of parliament were elected, MCAs were elected. It was clear that Jubilee won and President Uhuru Kenyatta won. So, personally, let me say, I think we are being treated to a comedy, right? As far as I'm concerned, we have only 2 days. We are only keeping the country in anxiety for unnecessarily.
Thank you.
And
right, Ken.
The faster these people agree that they lost election and plan for 2022, then better for this country, because Kenya must move on.
All right, and that moving on mentality is what people also are disputing. They don't want just to move on if there are ticklish issues to be addressed. Yeah?
I think what the senator is saying, most of it is correct, except that last point he's pushing there. I would say, first of all, there might be a presidential election in October. So we might be having an election in 60 days. Instead of telling us to prepare for 2022, should be telling us, let us all get prepared for 60 days. I can tell the country that too. You know, in my opinion, that's what I want to hear from the court. And I'll tell you why. First of all, I'm happy to observe, I watched most of it yesterday too, that this court has shown a willingness to not just rule on technicalities, but on substance, to see what serves the principles of justice. So when it came to rulings about what documents had been filed, at what time and lateness, they said, you know what? Let's overlook those. Let's give everybody a chance to bring their materials in and fully discuss the whole case. That did not happen in 2013. So we are at a step forward the way I think it. When it came
they excluded 3 affidavits from your party. 3 yesterday.
Okay, I'll grant that because I didn't see that part.
Yeah, they did.
Yes, okay.
They did as well.
But nevertheless, in terms of just allowing things, remember on the pre-trial conference the previous day, everything was being challenged and could have been thrown out the way it seemed like. I'm not a judge, but they allowed most of the things. So I think that is important. Number 2 is they granted read-only access to IEBC servers and all the Form 34 originals to be brought, 34As, 34Bs, and things like that. What is troubling for me is that IEBC hasn't shown that spirit of cooperation, which is one of the things on the headlines. IEBC fights back. What IEBC has offered and refused from yesterday 4 p.m. when the teams went to inspect the servers, to say, we won't allow you to inspect the servers, we'll print out for you some logs. Let the experts, and until this morning, I've just confirmed with some of the lawyers for our side, the NASA petition, that IEBC refused to grant the access and has said, no, we will give you only printed logs. That's a problem. Let's respect the courts, let's grant that access, because time is limited. Let's not have a hanging question or something.
But like I thought we had an order from the court.
Yes,
what is the order from the court reading? So are they floating the order from the court?
The server, read-only access, so you can't change things, but you can go in and scrutinize all the logs within the server as you want and check out for different data. You can't add new data, you can't alter data and anything like that. That's called read-only access.
Yes, so this is a violation
this was denied, has been,
access has been denied.
As a matter of fact, yes. IEBC said, no, we will print out for you. Tell us what you want, we'll give you printout. Or we've already printed out for you what we think you want. That's a problem. So I think that will be contested again this morning. I don't think it's a good way to...
That's a huge problem.
There you go.
That's a huge problem.
That is a violation of order.
Yes. Arbitrary, and in fact, they should be thrown out of the court. You can't do that.
You know, it's like if I say, you know what, allow Debarl and Senator Wamatangi and Miguna Miguna and Linturi to come to the cafeteria and have access to the food and serve themselves lunch. And you say, no, 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 no. They will come to the door, we will give them just the menu. This is what IEBC is doing. The court said, allow NASA to go in there and look at the whole buffet and serve themselves and probe and see what kind of diet you're serving. Say, no, 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 we will give them only the menu when they show up at the door. So that's going to be contested today. But let me tell you another thing. For me, there is a word called impunity. And how does impunity get its seeds planted and get itself rooted permanently that you can't attack it and take it back? This is the question here. Senator Linturi said the election is purely about numbers. The will of the voters, they voted, we know what the numbers are. Be that as it may, the other side of it is to look at is how do you define an election? Purely by the outcome in the numbers, or is an election to be looked at holistically? the whole process, the environment in which it was conducted, the impartiality of the people who conducted that election. Because if you say it's purely about numbers, we go to Azerbaijan and they've already announced the election results before they have voted. If it's purely about numbers, and everyone say that's spurious. You know, countries where the leader gets... So I think, to me, if the court rules and says the cumulative breaches of the law, you know, PLO Lumumba, I think, is one who said, the law does not concern itself with trivialities and little things. Yet, these are the same laws that actually exist. What examples of trivialities you think he was saying we should not concern ourselves with are examples of things like advertising and use of state resources in campaign by one side. That is actually forbidden in the law. So to say that it's a triviality that you shouldn't concern yourself. So the question is, cumulatively, those breaches in how the election was conducted, errors and violations of different elections.
Let's hear from Wamatangi.
Yeah. So do they matter or not? Or is it only the numbers that matter?
Your general observation.
Yeah. Thank you, Debarl. First, a question to you, because I see all of us, including behind me, is this board reading Decision 2017. Is it an implication that you also don't believe that a decision has already been made?
I hope you're saying this with your tongue firmly in cheek.
And I want to
light note, of course.
I want to affirm that a decision has already been made by Kenyans. They expressed their will on the 8th of August, and that will is known. And so I would want to recommend to NTV to change these boards behind us reading Decision 2017 and shift them to 2022 now. then we'll be looking forward. Now, without really getting into the merits, and I'm looking forward to the day when this matter is going to be over, then we can find the time and come here and really, extrapolate on these issues in detail, because there's a lot of things to talk about in this. But just two quick, very quick observations that I made yesterday. One, I believe, from what I observed, that the lawyers who put up the case for the NASA team very successfully yesterday managed, in front of the whole nation, to embarrass themselves, to shame themselves, really, for whatever merit or perception or social standing they held before. They really embarrassed themselves. That's my view. What they showed Kenyans, out of all the hula baloo and about the talk and the pandemonium built before this case, and then what they presented there and said really was, for lack of a better word, in some cases, laughable. And I don't want to get in most of these details, but I watched a lot of it, and I was surprised. For example, there was a line of thought that was advanced, or a line of argument that was advanced by an incoming senator who is a legal mind, that is Okongo Mogeni, and it was disastrous. You could even see from the expression of his colleagues around there. I mean, because there's a language called sign language which communicates. You could see from even his own colleagues. It is unbelievable what the guy was saying. I tried to follow some of, including one of the very respectable lawyers, Kangu, and he took us on another line where he transformed the court into a classroom because of lack of really content, and I don't want to get into some of those details. But the impression that was created by the presentation yesterday was very correct in the summary of what was offered by PLO Lumumba and Lawyer Mwite, that indeed the gentlemen were just on a fishing expedition, period. That's why you find they would try to make a complicated argument about graphs, and even when Orengo was trying to make his case, he could not even remember who is Y and who is Z. So there was a lot of talk about a graph, and this is Y, and this and this is Z. And then from there, if you looked at the argument, and I'm avoiding to get into the details because I have details I can really put on the table, but I'm trying to be reserved in that. But if you look at the way they structured the arguments, they started with the details of how the forms were transmitted and the anomalies. Then they shift quickly to an argument now by Mwalimu there that before you look at even this story that we are telling, look at the character and the nature of the election itself. Then somebody comes in here and brings a story about CSs, that what they were saying before the election amounts to, and you know, if you underline what the argument or the matter they took to court about, or what they went to court for, was that the election victory was stolen from them. And if you follow from the first story they told, the first time when they came to press, they said that there was hacking in the IEBC system. That was the public that was the main argument. They moderated that argument again, or modulated it, to now contain another new allegation about the forms. And then now from the forms, you started hearing the talk about CSs. From CSs again, now you started hearing talk about the quality of the electoral process, and then summarized there by some. You know, I think it was a pity. If you asked me, I would have advised the team that for just to retain their public standing and image, they would really have better walk away from this case. Right. At least they can save face. Okay. But they don't have a case.
But I think my friend has said uttered a lot of words which are meaningless. Because number one, with all due respect, Otiende was very good. He was the second best lawyer.
Well, that's your opinion. That's your opinion.
And he was clear. You may disagree with what he's saying, but I don't think that it would be fair to say that he was not very clear, that he was not articulate, that he did not try to present his points coherently. He did. And in fact, he did not confuse in the formula, the mathematical formula. The only thing Otiende corrected was he said multiple sign instead of X.
Yes.
He did not confuse Y and X. Yes. He did not say X. He said multiple. He thought it was multiple
X plus.
by.
Yes.
Yeah.
He did say he's also not a mathematician.
So that was. But
by the way, I followed.
The statisticians and the mathematicians that were watching understood what was going on. So that's number one. So we have to be fair. Number two. There are certain constitutional and good governance principles that came out, which I gleaned, which I need to emphasize.
First of all, before you go to the number two, because we've had on this forum that particular, the linear graph that we saw, yeah, and that particular formula.
And I said it was not mathematically possible.
Yeah.
And I think it is clear it is not mathematically possible. And I mean, if NASA can prove that the figures came in the way that Otiende presented in that graph, and the court buys it, that would be the end of the case. But I said if.
But how would
I said
a story like that?
I said
how?
If they can prove through access to the servers that the results came out the way they did.
Thank you.
And they did not come randomly.
Or we are not discussing the outcome of a case.
No, we are not.
Yeah,
I said if. But I was going to discuss the principles, and you drew me back to that.
Right, thank you.
So let me discuss these principles. Nyamodi, and by the way, Chief Justice, and because it was a public and we all watched it, Chief Justice asked, where did the figures that we were watching on TV come from? You know, he asked a very simple question. Where did these things come from? And Nyamodi tried to answer it and eventually made this statement. He said, the will of the people is resident in Form 34As. Right? That's what he said. Then he also said that as of August the 11th, 2017, Chebukati declared the results using Form 34Bs. And he had not had all Form 34As. Then Issa Mansour, in his submissions on behalf of Chebukati, made this startling statement. Form 34As are not mandatory in declaring the results for the president, he said. Only Form 34Bs. The question, and I'm not going to answer the question then is, how do you get Form 34Bs without Form 34As? It's the chicken and the egg. Even better, because you know the chicken comes from the egg, but the chicken is the one that lays the egg. In this case, we know that there is no Form 34Bs without Form 34As. Now, this is what I think was lost in the tendency of the advocates trying to outdo each other and confuse the audience. People, and I believe we are going to come to this point, even the court will make sure that we appreciate this. The IEBC is a public body. It is not a private entity. The citizens of Kenya, including the voters, but not only the voters, pay for the existence of the IEBC chair, Ezra Chiloba, and all of them. It has a positive duty, constitutional, legal, and moral, to conduct fair, transparent, and credible elections. And it does not need anyone to tell them to do that. And it does not require anyone to petition them to do that. And it has a positive duty to deliver all the evidence to the court without compulsion, without Raila Odinga or anybody else telling them to do so. That is why the order yesterday was the correct order. Go in there, mine the data, don't alter anything, come back and tell us what you have seen. Because this is a public body. But the lawyers representing the IEBC, and probably the IEBC people, the officials, have not gotten it into their mind that they are not fighting Raila Odinga or the petitioners in courts. All they are required to do as a duty is to explain to the court and to the people of Kenya that we conducted elections constitutionally, legally, and the results we announced were correct.
Thank you.
And so the winner we announced was the correct winner.
All right, let's hear from Mithika. We'll come to Mithika. We'll come to you, Wamatangi.
No.
Mithika.
I mean, we are making comments based on the case.
Those arguments would have been best off in the court of law.
I didn't stop being a lawyer.
Listening to Miguna is like you and some conspiracy with Miguna. Because I can see Miguna as a serious paper that is written where he's making a reference to. And even quoting the
thing is, Miguna knew, no, just a moment. No, that is a very serious allegation. Because the thing is, Miguna knew he's coming to the show, and he's coming prepared.
But
you knew you're coming to the show, you are not prepared. Yeah? So you can... So you cannot say there's a collusion. He's just prepared. You're not. And if you're not prepared, let's hear from Ken.
Actually,
all right, just a moment, please. Okay, Mithika Linturi.
Kind of is getting into trying to determine the merits of this case.
We are not talking about the merits and the merits of the sex.
On what we watched yesterday.
Your observation.
Then I didn't watch.
Yes, so you have nothing to say.
Right?
So you have nothing to say.
But don't complain about me commenting.
No, I am not complaining. It's the detail in which you are giving your submissions. The detail, right?
To help Kenyans
to the extent that you are likely.
All right, thank you.
You are likely to change
your comment, please. If you don't have, we cross over to Ken.
No.
I think the judges are watching. And Debarl,
yes,
we've talked enough about the court, right?
Yes.
I think we should talk about the plastic ban. This affects Kenyans also.
Correct.
In their pockets, in their wallets, in the environment we live in. But if you still want to talk about the court, the election is, to me, and this is a question we must address ourselves, the spirit and the process in which it's conducted according to the laws and the laid down guidelines in the Constitution. If you don't follow those, can we say you have held a valid election? That is the question. And if NASA is proving in court that these were severe continuous breaches, because if the court upholds, yes, those breaches existed, but those people should be held accountable in a different way, we uphold still the outcome, then it will be in the future that you will find anyone who can manipulate the system but come up with the numbers, say, just look at the numbers. How we conducted the elections, how we didn't follow the constitutional principles, how we broke the election laws and committed these violations, all don't matter. The will of the people as elected in that poorly conducted election is still fine. That to me is a big question, but we will let the court decide. Now there's important issues which went to court, of course, last week.
Can I make a quick comment on the court?
Let Wamatangi,
before we move to that,
we are winding up here as well.
A very quick one on the court, because I think really, the way one would argue when you take a matter to court, and I think this is the story behind NASA's failure, or will be the story, and I don't want to predict, but for them, but I can see it is going to be a failure, in my opinion, because you see, if you take one of the qualities of a good case that you take to court is you take an argument to court and you sustain that argument consistently with the facts that you have taken. And you say,
let him finish, please. Let him finish.
What's wrong with you? I told you this.
You have not argued.
I mean, Miguna, please let him finish. We are strapped for time. Let him make his point. No, just a moment. Just let him finish.
Because you went to study law.
Does
not mean that you have a monopoly of thoughts.
But
okay, Miguna, just give him time.
Have you argued cases in court?
My friend, I have made arguments not only in court, but in the whole world.
No, in court.
I mean, in private and in public.
We are talking about...
All right.
What is wrong with you, man? Stop this exclusive thinking.
This is a family show. Let's not go to the private arguments. Can we go to plastic?
Yes, please. Let's go to personal. Just wind up on the issue.
So just so that this gentleman can hear me well. What I'm saying, Debarl, the nature of a good argument, and a case is an argument you're taking to court. You have to make that argument, take your facts there, sustain that argument consistently. And you see, indeed, in one of the arguments that was brought by one of the lawyers for the respondents was, and is very telling, he said, and it is a requirement of law, that you cannot use what you are submitting, your own submissions, to introduce new evidence.
Thank you.
This is the problem with the nature of the NASA case.
All right, thank you.
And that's why I called it a fishing expedition, because with everything that they want to submit, they look for new things to say. That's why you find Ken now is talking about the nature of an election. If you conduct an election that you say is not good, does it amount to an election? So you see, the argument that NASA took to court was first that the election results were erroneous because there was hacking in the system, and the election was stolen.
Thank you.
That is the argument they need to sustain.
Your closing remarks, please.
But the rest of these are the stories you are bringing about the quality of the election, whether there was campaigning by CSS before.
All right, Wamatangi, thank you. Miguna, your closing remarks, please.
My closing remarks is that this case is very important, and it is important jurisprudentially, it is important politically, it is also important for the nation as a democratic exercise, so that at the end of the day, when and if it is done properly, we can put the issue of the elections behind us. Whether we are going to have a rerun or we are going to conclude the matter, at least the court will do that, but we must treat it as a judicial exercise. We cannot say that we cannot comment on it. The only thing we cannot comment on are the results.
The outcome.
The sub judice rule does not gag anyone. It simply says you cannot comment on the results.
Thank you. Thank you very much. Mithika, Linturi, your closing remarks.
Yeah, my closing remarks are that certain principles have been set out in Article 86 of the Constitution in terms of how electoral processes or a free and fair election must be conducted. And for avoidance of doubt, that particular provision says the election has to be simple, accurate, verifiable, secure, accountable, and transparent. As long as or the petitioners in this case have only a duty to prove malpractices in the last election by trying to prove that some of these the same principles were not followed, then they will have a case. If they are able to prove that there was intimidation, bribery, or any other kind of malpractice, then they will have a case.
Thank you, Ken.
But in the absence of all this, I personally feel that they may not be able to really substantiate their case.
All right, thank you very much, Ken.
I think if we go with a situation where we say it doesn't matter how the elections were conducted, it doesn't matter any deliberate or non-deliberate mistakes were made in how the election is conducted, all that matters is some result came out. Then we will have impunity. We will have, Kenyans accustomed to, just go do any Malogodania with 40 billion, which we paid the IEBC to run this election, and then come and tell us he is a winner. So this is not about Raila, this is not about Uhuru. This is about setting the rules and saying in future, IEBC and all participants in the elections must follow the rule. And if you follow the rule of law and do what is correct, then that is valid. But if you don't follow the rules, whatever comes out of it
30
is
seconds.
not valid.
Very briefly.
I just want to make my closing remarks by saying to the Kenyan people, yes, and we need this country to move forward. We want this case to be closed as fast as possible. We are hopeful that the Supreme Court will adjudicate on it and rule as fast as we should. By Friday, on Saturday morning, the country moves forward, and then we are able to move. And let me say to my friend here, when he says that have I made arguments, I want to tell him his boss always talks about the court of public opinion. And we have made many arguments all over the world. Your former boss.
Thank you very much.
We have made many arguments in the course of public opinion.
Thank you very much. We're winding up, guys. Wamatangi, we're winding up. Thank you.
And my friend Ken.
The show is over.
It's over. Thank you for
my
your...
friend Ken, I tell you that you
All right, thank you
spoke
for your
about
valid campaign.
sacrificing.
Really do appreciate you
Next
coming
time
to this
when we meet in the house, I'll be running for speaker. This time I sacrificed to run for deputy.